This meeting of the House Judiciary Task Force on Judicial Impeachment will now come to order. Pursuant to notice, we will now consider articles of impeachment against U.S. District Judge Samuel B. Kent for recommendation to the full committee. A proposed resolution containing the articles of impeachment was distributed to members of the task force earlier. After our meeting today, if articles are approved for recommendation by the task force, I plan to file an impeachment resolution with a ranking member that contains those articles and would invite any of my colleagues on the task force to be original co-sponsors of that resolution. The clerk will now report the proposed resolution containing the articles.
A draft resolution impeaching Samuel B. Kent, Judge of the United States District Court for the Southern District of Texas, for high crimes and misdemeanors. Resolves that Samuel B. Kent, a judge of the United States District Court for the Southern District of Texas, is impeached for high crimes and misdemeanors, and that the following articles of impeachment be exhibited to the Senate. Articles of impeachment exhibited by the House of Representatives of the United States of America and the name of itself and all of the people of the United States of America against Samuel B. Kent, a judge of the United States District Court for the Southern District of Texas, and maintenance and support of its impeachment against him for high crimes and misdemeanors. Article 1.
Without objection, the draft resolution is considered as read and open for amendment. We will proceed through the proposed resolution article by article. I now recognize myself for the purpose of making an opening statement. This task force meeting has been convened as part of our continuing inquiry into whether U.S. District Court Judge Samuel B. Kent should be impeached by the U.S. House of Representatives. In August 2008, a federal grand jury returned a 3-count indictment against Judge Samuel Kent after a Department of Justice criminal investigation. A superseding indictment filed in January 2009 added 3 additional counts for a total of 6 counts charged. According to the indictment, Judge Kent is alleged to have committed acts constituting abusive sexual contact and attempted aggravated sexual abuse in 2003 and 2007 against Ms. Kathy McBroom, a deputy clerk occasionally assigned to Judge Kent's courtroom. Judge Kent is also alleged to have committed acts constituting aggravated sexual abuse and abusive sexual contact from 2004 through at least 2005 with Ms. Donna Wilkerson, Judge Kent's secretary. Aggravated sexual abuse is a crime punishable under 18 U.S.C. 2241 by up to life in prison. Finally, the indictment charges Judge Kent with 1 count of obstruction of justice for corruptly obstructing, influencing, and impeding an official proceeding by making false statements to the Special Investigative Committee of the U.S. Court of Appeals for the Fifth Circuit regarding his unwanted sexual contact with Ms. Wilkerson. On February 23, 2009, the day his criminal trial was set to begin, Judge Kent pled guilty to obstruction of justice. As a part of his plea, he admitted to engaging in non-consensual sexual contact with Ms. McBroom without her permission in 2003 and 2007. Judge Kent also admitted to engaging in non-consensual sexual contact with Ms. Wilkerson without her permission from 2004 through at least 2005. Finally, he admitted that he falsely testified before the Special Investigative Committee of the Fifth Circuit regarding his unwanted sexual contact with Ms. Wilkerson. In particular, Judge Kent admitted making false statements with regard to his repeated non-consensual sexual contact with Ms. Wilkerson. On May 11, 2009, Judge Kent was sentenced to a term of 33 months in prison in order to pay fines and restitution to Ms. McBroom and Ms. Wilkerson. Judge Kent is ordered to surrender himself on June 15 for incarceration. The day after his sentencing, the House of Representatives passed House Resolution 424 by unanimous consent, authorizing and directing this task force to inquire whether Judge Kent should be impeached. On June 3rd, the task force held an evidentiary hearing to determine whether Judge Kent's conduct provides a sufficient basis for impeachment and to develop a record upon which to recommend whether to adopt articles of impeachment. At the hearing, we heard from Alan Barron, Special Impeachment Counsel of the task force, who submitted a number of official documents related to this matter into the record. These included Judge Kent's plea, where he pled guilty to obstruction of justice in violation of 18 U.S.C. Section 1512c2. The task force then took testimony from the following witnesses: Ms. Kathy McBroom, a clerk who occasionally was assigned to Judge Kent's courtroom, Ms. Donna Wilkerson, a secretary to Judge Kent, and Professor Arthur Hellman from the University of Pittsburgh School of Law. Ms. McBroom and Ms. Wilkerson both testified that they were sexually assaulted by Judge Kent on numerous occasions and detailed a number of these incidents to the task force. Professor Hellman provided expert testimony that concluded that making false statements to fellow judges as well as abusing his power as a federal judge to sexually assault women, were independent grounds that would justify Judge Kent's impeachment and removal from office. In particular, Professor Hellman noted that historical precedent provides that the phrase high crimes and misdemeanors, the constitutional standard to justify impeachment, generally describes acts that constitute an abuse of power or otherwise render a judge unfit to hold office. Professor Hellman, in his expert opinion, concluded that the facts in the record rose to the level as to warrant Judge Kent's impeachment. As was mentioned during the hearing, the task force invited Judge Kent to testify, but he declined this offer. The task force received correspondence from Judge Kent that was made available to all members and entered into the record. The task force also invited Judge Kent's counsel to participate in the hearings, to present arguments on behalf of his client, as well as the opportunity to question any of the witnesses. Judge Kent's counsel also declined to appear or participate in the hearing. Article 1, Section 2 of the Constitution vests the sole power of impeachment in the House of Representatives. Article 3, Section 1 provides that the judges both of the Supreme and inferior courts shall hold their offices during good behavior and shall at stated times receive for their services a compensation which shall not be diminished during their continuance in office. Article 2, Section 4 of the Constitution provides that all civil officers of the United States shall be removed from office on impeachment and conviction of treason, bribery, or other high crimes and misdemeanors. As we have learned, historical precedent indicates there are two categories of conduct that may justify impeachment: serious abuse of power and conduct that demonstrates an official is unworthy to fill the office that he holds. Accordingly, I believe that the full record before us establishes that Judge Samuel B. Kent should be impeached for high crimes and misdemeanors. Judge Kent, incident to his position as a U.S. District Judge, engaged in deplorable conduct with respect to employees associated with the court. Such conduct is incompatible with the trust and confidence placed in him as a judge. In particular, the record demonstrates that Judge Kent sexually assaulted Ms. Kathy McBroom and Ms. Donna Wilkerson, both employees of the court, on one or more occasions. Furthermore, Judge Kent corruptly obstructed, influenced, or impeded an official proceeding when he made false statements to the Special Investigative Committee of the U.S. Court of Appeals for the Fifth Circuit. Finally, the record demonstrates that Judge Kent made material false and misleading statements about the nature and extent of his non-consensual sexual contact with Ms. McBroom and Ms. Wilkerson to agents of the FBI and to representatives of the Department of Justice. These acts of sexual assault and obstruction of justice are, as the judge who sentenced Mr. Kent to incarceration stated, a stain on the justice system itself. Were the House of Representatives to sit idly by and allow Mr. Kent to continue to hold the office of a U.S. District Judge while sitting in prison, and after committing such high crimes and misdemeanors, it would be a stain on the Congress as well. After seeking and receiving input from task force members, draft articles have been prepared for the task force consideration today. Before we proceed, we have an additional 3 documents to make a part of the record. They are the following: a certified copy of the judgment, a memorandum of interview signed by Alan Barron, Special Impeachment Counsel to the task force, summarizing an interview with FBI Special Agent David Baker, and a memorandum of interview signed by Kirsten Konar, Esquire, counsel assisting the task force, summarizing an interview with Ms. Donna Wilkerson. Without objection, these 3 documents will be made part of the record. We have also subsequently received FBI 302s and grand jury testimony that are available to members. I now recognize the ranking member of the task force, Bob Goodlatte of Virginia, for an opening statement.
Well, thank you, Mr. Chairman, for holding this important markup. Article 3 of the Constitution provides that federal judges are appointed for life and that they shall hold their offices during good behavior. Indeed, the framers knew that an independent judiciary free of political motivations was necessary to the fair resolution of disputes and the fair administration of our laws. However, the framers were also pragmatists and had the foresight to include checks against the abuse of the independence and power that comes with a judicial appointment. Article 1, Section 2, Clause 5 of the Constitution grants the House of Representatives the sole power of impeachment. This is a very serious power that should not be undertaken lightly. The impeachment of a federal judge is a very infrequent occurrence within the halls of Congress. In fact, no federal judge has been impeached in the last 20 years. It is a power that Congress utilizes only in cases involving very serious allegations of misconduct. However, when evidence emerges that an individual is abusing his judicial office for his own advantage and the integrity of the judicial system becomes compromised, and the House of Representatives has the duty to investigate the matter and take the appropriate actions to end the abuse and restore the confidence in the judicial system. This task force has taken the testimony of 2 women victimized by Judge Kent. The task force has also taken other expert testimony and has conducted its own investigation, including working with the Fifth Circuit, the Department of Justice, the FBI, and other parties to gather relevant evidence. These efforts have yielded information that paints the clear picture that Judge Kent has engaged in conduct, including obstruction of justice and repeated sexual assaults on court employees, which merit the very serious step of this task force recommending articles of impeachment against Judge Kent. Specifically, by his own admission, Judge Kent lied to the investigative committee of the Fifth Circuit, which was looking into the misconduct involving 2 court employees. Judge Kent pled guilty to the felony obstruction of justice charge and will serve 33 months in federal prison beginning on June 15th. However, the evidence has shown that Judge Kent also separately lied to the Department of Justice and the FBI when questioned about the nature of his contacts with these women. In addition, Judge Kent has admitted to engaging in non-consensual sexual contact with at least 2 court employees. At a hearing convened by this task force on June 3, 2009, we heard the stories of the 2 women that Judge Kent victimized. These stories filled in the gaps in Judge Kent's admission and showed the repeated violent sexual abuse of these 2 women. It is worth noting again that Judge Kent was invited to appear at the hearing before the task force and explain why his conduct does not justify impeachment. His attorney was also invited to participate. However, both Judge Kent and his attorney declined to attend. Based on the evidence that has been gathered by the task force during its investigation, we now present 4 articles of impeachment for the task force members' consideration. The first article describes the repeated sexual assault on Donna Wilkerson, a court employee. The second article describes the repeated sexual assault of Kathy McBroom, another court employee. The third article describes the obstruction of justice with respect to Judge Kent's false statements during the Fifth Circuit Special Investigatory Committee proceedings. And the fourth article describes the false statements Judge Kent made to the Department of Justice and the Federal Bureau of Investigation when they questioned him about his conduct. It is my strong recommendation that the task force recommend these articles of impeachment to the full Judiciary Committee for further consideration. Thank you, Mr. Chairman.
I thank the gentleman for his statement. Are there other committee members that wish to be recognized for an opening statement? Ms. Sheila Jackson Lee of Texas.
Thank you very much, Mr. Chairman. I think I will yield the majority of my remarks for our meeting tomorrow, but I am interested in submitting several statements on the psychiatric condition of Judge Kent to the record, please.
Without objection, those will be made a part of the record. I thank the gentleman. Gentlewoman, would other committee members like to be recognized? The gentleman from Texas, Mr. Gohmert.
Yes, it's been referenced that Judge Kent was given the opportunity to be here. He was given notice, and I don't think this, everyone had mentioned, well, his letter says, my health does not presently allow me to travel to Washington. This is a judge who'd been found guilty of lying on multiple occasions, a judge who was found guilty of obstruction of justice for lying. He submits an unsworn letter knowing that his credibility is a very, very serious issue and just says, my health. No supporting documentation, nothing to go along with it. And so I just wanted that noted for the record, that is, as a federal judge, knowing the importance of credibility, knowing that the evidence was he didn't have much in the way of credibility, he sends a letter without any support for the fact that his health did not allow him to travel. Just wanted to note that. Thank you.
I thank the gentleman. Mr. Pierre-Louis C. of Puerto Rico.
Just briefly, that I just want to add that it is fair to assume that most individuals in Judge Kent's position would have resigned their position immediately. Yet, Judge Kent purported to resign effective June 1st, 2010, nearly 1 year from now. And I say purported to resign because Judge Kent could withdraw his letter of resignation at any time and continue to hold his position into the future, apart from all these allegations. So he basically gave us no choice but to do what we're doing here today.
I thank the gentleman for his statement. Other member statements may be made a part of the record and included in the record. At this point, we will proceed through the articles, and I would ask the clerk to read the first article.
Article 1. Incident to his position as a United States District Court judge, Samuel B. Kent has engaged in conduct with respect to employees associated with the court that is incompatible with the trust and confidence placed in him as a judge as follows. 1. Judge Kent is a United States District Judge in the Southern District of Texas. From 1990 to 2008, he was assigned to the Galveston Division of the Southern District, and his chambers and courtroom were located in the United States Post Office and Courthouse in Galveston, Texas. 2. Kathy McBroom was an employee of the Office of the Clerk of the Court for the Southern District of Texas and served as a deputy clerk in the Galveston Division assigned to Judge Kent's courtroom. 3. On one or more occasions between 2003 and 2007, Judge Kent sexually assaulted Kathy McBroom by touching her private areas directly and through her clothing against her will and by attempting to cause her to engage in a sexual act with him. Wherefore, Judge Samuel B. Kent is guilty of high crimes and misdemeanors and should be removed from office. Article 2.
If the clerk could hold there. Is there any discussion on the amendment, or do any of the members have any amendments to offer to Article 1? Hearing none, the clerk will please report Article 2.
Article 2. Incident to his position as a United States District Court judge, Samuel B. Kent has engaged in conduct with respect to employees associated with the court that is incompatible with the trust and confidence placed in him as a judge as follows. 1. Judge Kent is a United States District Judge in the Southern District of Texas. From 1990 to 2008, he was assigned to the Galveston Division of the Southern District, and his chambers and courtroom were located in the United States Post Office and Courthouse in Galveston, Texas. 2. Donna Wilkerson was an employee of the United States District Court for the Southern District of Texas. 3. On one or more occasions between 2001 and 2007, Judge Kent sexually assaulted Donna Wilkerson by touching her in her private areas against her will and by attempting to cause her to engage in a sexual act with him. Wherefore, Judge Samuel B. Kent is guilty of high crimes and misdemeanors and should be removed from office.
Are there any amendments to Article 2? Hearing none, the clerk will report Article 3.
Article 3. Samuel B. Kent corruptly obstructed, influenced, or impeded an official proceeding as follows. 1. On or about May 21st, 2007, Kathy McBroom filed a judicial misconduct complaint with the United States Court of Appeals for the Fifth Circuit. In response, the Fifth Circuit appointed a special investigative committee, hereinafter in this article referred to as the committee, to investigate Kathy McBroom's complaint. 2. On or about June 8, 2007, at Judge Kent's request and upon notice from the committee, Judge Kent appeared before the committee. 3. As a part of its investigation, the committee sought to learn from Judge Kent and others whether he had engaged in unwanted sexual conduct with Kathy McBroom and individuals other than Kathy McBroom. 4. On or about June 8, 2007, Judge Kent made false statements to the committee regarding his unwanted sexual contact with Donna Wilkerson as follows. A. Judge Kent falsely stated to the committee that the extent of his unwanted sexual contact with Donna Wilkerson was one kiss, when in fact, and as he knew, he had engaged in repeated sexual contact with Donna Wilkerson without her permission. B. Judge Kent falsely stated to the committee that when told by Donna Wilkerson his advances were unwelcome, no further contact occurred, when in fact, and as he knew, Judge Kent continued such advances even after she asked him to stop. 5. Judge Kent was indicted and pled guilty and was sentenced to imprisonment for the felony of obstruction of justice in violation of Section 1512C2 of Title 18, United States Code, on the basis of false statements made to the committee. The sentencing judge described his conduct as a stain on the judicial system itself. Wherefore, Judge Samuel B. Kent is guilty of high crimes and misdemeanors and should be removed from office.
Are there any amendments to Article 3? Hearing none, the clerk will report Article 4.
Article 4, Judge Samuel B. Kent made material false and misleading statements about the nature and the extent of his non-consensual sexual contact with Kathy McBroom and Donna Wilkerson to agents of the Federal Bureau of Investigation on or about November 30th, 2007, and to agents of the Federal Bureau of Investigation and representatives of the Department of Justice on or about August 11th, 2008. Wherefore, Judge Samuel B. Kent is guilty of high crimes and misdemeanors and should be removed from office.
Are there any amendments on Article 4? Hearing none, the question is on recommending to the committee for adoption the articles of impeachment as contained in the draft resolution. We have agreed to do this by roll call vote. As your name is called, those in favor will say aye. Those opposed will say no. The clerk will call the roll.
Ms. Jackson-Lee. Ms. Jackson-Lee votes aye. Mr. Delahunt. Mr. Cohen. Mr. Cohen votes aye. Mr. Johnson. Mr. Johnson votes aye. Mr. Pierluisi. Mr. Pierluisi votes aye. Mr. Gonzalez. Mr. Goodlatte. Aye. Mr. Goodlatte votes aye. Mr. Sensenbrenner. Mr. Sensenbrenner votes aye. Mr. Lundgren. Mr. Lundgren votes aye. Mr. Forbes. Mr. Gomer. Mr. Gomer votes aye. Mr. Schiff.
Aye.
Mr. Schiff votes aye. Mr. Chairman, we have
Does any other member wish to vote?
Mr. Delahunt. Mr. Delahunt votes aye.
Does any other member wish to cast his or her vote? The clerk will report.
Mr. Chairman, we have 10 ayes and 0 nays.
A majority have voted in favor. The articles of impeachment as contained in the draft resolution are forwarded to the committee with a recommendation that they be adopted. There being no further business before the task force today, we are adjourned.